All right, everyone. So I'm going to do my best Heimler impersonation and give you the notes for Unit 3, Civil Liberties. And so remember, we're talking about how to protect our individual rights. Now, this unit is one of my favorites because we finally get to see in action what the founders were talking about, the ideas and ideals that they had in their minds about what it meant to live in a free society. Unit 3, in the cases we're about to talk about, really exemplify what the founders had in mind, and in some aspects, what they didn't think of. So, one of the things that we're going to be talking about first is this idea of freedom, right? And so, the Freedom House, which is a think tank, did a survey several years ago, and they rank ordered the major countries and what it meant to be free. So, here we see the United States with a ranking of number 6, meaning it is the most free. And we see China and Russia with a score of 1, meaning the least free. So I want you to think a minute about Mexico and Guatemala, for example. How do you think the rights in Mexico and Guatemala differ from that of, say, the United States or Japan? So just think about that. And the areas that were looked at for the survey looked at free expression, organizational rights, rule of law, and personal autonomy. So think about what each one of those means: free expression, organizational rights, rule of law, and personal autonomy. Now, as we kind of go through the civil rights unit and civil liberties units, what we're talking about here is three big concepts. And that has to do with the items found in the Bill of Rights, the 14th Amendment, and this idea of selective incorporation, which we'll talk about in a moment. So, before we begin or go any further, rather, let's talk about what civil liberties actually means. So, civil liberties means specific individual rights, such as the right to a fair trial, and these rights are constitutionally protected against infringement by the government. So, these are the things that the Anti-Federalists were fighting for. These things were what the government could not do. Okay, so we're thinking back to, 1776, the American Revolution, and what the people were afraid of. And they were afraid of a monarchical government that had a tyrannical figure who was going to take away freedoms. They were going to disappear you. They were going to use the government to infringe on individual rights. And so the founders wanted to make sure that this new government, this new experiment in democracy, would have protections against that. And so civil liberties, again, these are things that are guaranteed to every citizen and are constitutionally protected against infringement by the government. The government can't take these things away. Now, where are most of these things enshrined? Well, the biggest one is the Bill of Rights. The first 10 amendments, these list a bunch of the things that the federal government is obligated to protect and things that they cannot do. Okay. And the next one is the 14th Amendment's Due Process Clause. Now, here we have a clause that prevents the states from abridging individual rights. And this seems kind of intuitive now, but as we will see when we talk a little bit more in depth about selective incorporation, the Supreme Court really had to say, hey, yes, the federal government can't do these things. The citizens are protected against, say, censorship from the federal government. But what about the states? Because for a very long time, the states could very much infringe upon those rights, even if the federal government could not. And so this is going to be one of the Supreme Court's, biggest battles, is to say what the states cannot do as well. And that's going to be through the use of the 14th Amendment's Due Process Clause. Now, when we're talking about selective incorporation, we're talking about how the Supreme Court really kind of started to weigh into this conversation. So if we're thinking about back in the day, especially think the 1960s, the civil rights era, we see the Supreme Court having to answer questions about what can the states do? And if the states can do it, why can't the federal government do it? Oh, the federal government can't do it because it's constitutionally protected. Oh, then maybe we should reevaluate whether or not the states should be able to do the same thing. And so one of the things that this usually or initially came up against was things in the First Amendment. And so in the First Amendment, we see that there are four big things that are protected. Number one is speech, press, assembly, and religion. Now, for speech, you're free to say almost anything. Okay? Almost. Okay? Almost anything. The Supreme Court has put in some boundaries as to things that are not acceptable, things like obscenity, things that slander another person, or something that is going to incite others to take imminent and lawless action. For the press, you're free to write or publish almost anything, except things that are obscene. It libels another person, it endangers military action or national security, or just like with speech, has a high probability of inciting others to take imminent lawless action. Now, with assembly, you're free to assemble, although there's going to be some regulation. So, again, all of these rights, all of these liberties are going to have some sort of boundaries. They are not absolute, okay? They have boundaries. In terms of religion, you're protected from having the religious beliefs of others imposed on you, and you can believe whatever you want. The issue comes to be with things like how you exercise that religion. So if your religion believes in human sacrifice, you can't go, sacrifice your neighbor. Okay, so you can believe in whatever you want, but that does not mean that you can express it. And so when we talk again about freedom of expression, what we're talking about is the idea to believe something and then do something about it, right? So to be able to express those rights. So one of the first instances in our new democracy that this idea of freedom of expression was, well, that it started to kind of seem that maybe it wasn't as strong of a right as perhaps the founders had anticipated, was in 1798. So really right after the Bill of Rights were enshrined in the Constitution, where we see the Sedition Act of 1798. And here, basically, if you said anything negative about the president or the government, they were going to imprison you. Like, case shut. That was it. And today we're like, well, maybe that wasn't such a good idea. Maybe that was unlawful. Maybe that ran against this idea of freedom of expression. Now, even though we know it's unlimited, not being able to speak out against the government seems like that should probably be a fundamental right. So the Sedition Act of 1798 ultimately was found unconstitutional. Now, today, if freedom of expression is protected, I would say it's protected way more vigorously than it was, say, in 1798. However, again, it is not absolute, and it can easily be denied if it runs afoul of national security, if it's talking about or damaging other people's reputations, or if it starts to deprive others of their rights. So if it starts to do any of those things, no more freedom of expression for you. Okay, so we're going to talk about some cases in a few minutes that are going to talk about this as well. But the ultimate kind of takeaway of this is that freedom of expression, just like freedom of speech, just like freedom to assemble, all of these things are not absolute. They're not unlimited. In terms of free speech, okay, we've had some 20th century challenges. All right, so in 1917, we have the Espionage Act in Schenck versus United States. In 1919, we have some national security situations. And then we start seeing the government start to weigh in on this a little bit, start to try to establish boundaries. And now this, again, was going to be Congress starting to do things, and the court then having to check Congress and say, hey, is this constitutional, and utilize their power of judicial review, which was established in Marbury versus Madison. And so what the court has to start saying, well, what about national security? If I do something that's against national security, how much is protected? In the 1950s, when we had the Red Scare, when we had all of the Cold War situations, now we're thinking, again, what is it that I can and can't say against the government, or in terms of military movements or protesting against military actions, things like that. And so the Supreme Court ended up coming up with a test called the clear and present danger test, where it said, okay, well, your speech is unlimited until it starts becoming a clear and present danger. And that means that your speech was going to cause some sort of danger to happen. And so one of the ways we see that is you can't yell fire in a crowded theater. You can't yell bomb on a plane, for a modern example. You can't yell, certain things where it would cause people to panic and ultimately run the risk of people getting hurt. The other thing is hate speech. Okay, when we're talking about hate speech, it's protected. Okay, but if hate speech leads to hate crimes, not protected. And one of the biggest places we see some hate speech being protected is the Westboro Baptist Church protests. And you can kind of look that up on your own. But essentially, members of this Westboro Baptist Church wanted to and did protest the funeral of military soldiers who were killed in Iraq and Afghanistan, and it got pretty ugly. And so hate speech is protected. However, if that hate speech kind of starts lending itself to hate crimes, that is absolutely not protected. And lastly, we have symbolic speech. Okay, these are actions. These are actions, not words, and it's protected, but less completely than actual verbal speech. So these are going to be things on your clothing. Think tinker and the armband. That is symbolic speech. When we have freedom of assembly, you can't just have a protest wherever you want. The government can and will place restrictions on the time, place, and manner, especially to keep everyone safe. So, can very extremist political groups have a parade? Sure. But where they can have that parade, when they can have that parade, and in the manner in which they can have that parade is going to be set by the government. Okay, they still have to abide by those things, but they do still get to have the parade. For example, when we talk about freedom of press and libel law, we usually talk about one big case, and that's going to be New York Times versus United States. And this is a 1971 case, and we also refer to it as the Pentagon Papers case. And basically here we have a situation where some things were going to come out that made the government look very bad in terms of the actions during the Vietnam War. And so the government wanted to kind of get ahead of the publication of these papers, saying that it was a national security threat. And the Supreme Court, in this case, literally ruled the fastest it has ever ruled in its history. And I think it took less than 30 days for the court to accept the case, hear the case, decide the case, which is unprecedented. And so in the New York Times case, basically, we can't have this thing called prior restraint. And so the government can't prohibit speech before the speech occurs. So I can't preeminently say, hey, you can't say that if you haven't said it yet. Okay. And the burden of proof is going to be on the government to prove why this prior restraint is necessary. And ultimately, in 1971, the government couldn't show beyond a reasonable doubt that the Pentagon Papers detailing those actions in Vietnam years prior were going to be of such of an issue that the public should not hear it, like a national security issue. And then we have this thing called libel. Okay, and this is where you publish material that falsely damages a person's reputation. Now, let me be very clear. It is not libel if it is true. Okay, so if Cindy is a terrible person and Cindy stole her neighbor's cat, and you publish in the paper that Cindy is a thief for selling or for taking her neighbor's cat, that is not libel because it is true. Okay, it is true. So libel is only the publishing of material that damages a person's reputation and is false. Slander. These are just going to be words that falsely damage a person's reputation. So libel is publishing, so written words, and slander is going to be spoken words. Okay, spoken words. Now, we won't go into this too terribly much, but when we're talking about public officials, there's a different threshold of what that's going to look like. Okay, in terms of what's protected. When we have freedom of religion, okay, as we were talking about a second ago, expressing your religion, believing in your religion, that's all fine and dandy. The First Amendment absolutely protects your right to believe whatever it is that you want to. However, what it does not do is protect the right to express it however you want to. Think human sacrifice, kind of not okay. All right. And so within religion in the First Amendment, there's two major clauses we have to talk about: the establishment and the free exercise clauses. So in the first one, the establishment clause basically says, hey, the government can't favor one religion over another or support one religion over no religion. Okay. This is the idea of a separation between church and state, as well as an accommodation. Okay. And the Supreme Court has said, okay, well, if we're going to kind of evaluate this, we need to have a way to evaluate that. And that test is going to be that Lemon test. And so the Lemon test has three major parts. The first is that the policy must have a non-religious purpose. Its principal or primary effect must be one that neither advances nor inhibits religion, and it must not foster an excessive government entanglement with religion. Now, here's the thing. The Lemon test is no longer in use as of about 2 years ago in a case called Kennedy versus Bremerton, where the modern Supreme Court basically said, listen, this Lemon test is outdated. We don't know what any of these words mean, and we're going to come up with something new. Okay, so the free exercise. Well, what does that mean? That means that the government is prohibited from interfering with the practice of your religion. Okay, government interference is allowed when the exercise of religious beliefs conflicts with otherwise valid law. Okay, think back, human sacrifice. Can't murder people, can't sacrifice people. There's been some very controversial cases in the last 10 years or so. One of which is Burwell versus Hobby Lobby. In this case, we have the Hobby Lobby stores, which is a corporation, not complying with Obamacare's mandate to give female employees birth control as part of their insurance coverage. And we see, for some various reasons, that the Supreme Court basically says, listen, this government or this corporation, Hobby Lobby specifically, is a small enough corporation and they don't believe in abortion, so they are not going to elect to have birth control as part of the insurance coverage that they offer their employees. Then we have Masterpiece Cake Shop versus Colorado Civil Rights Commission. Masterpiece Cake Shop did not want to bake a cake for a same-sex couple in Colorado in 2018. And basically, the court says, listen, if you're going to be in the public space and sell your cakes to the public, then you have to be able to do that. Okay. Now, we'll skip that one. Then we have the right to bear arms. So obviously, Second Amendment, we know what it means. It's exactly what it says it is, but the court has only talked about it twice. Okay, in 2008 and in 2010. So in 2008, in District of Columbia versus Heller, basically the court ruled that the Second Amendment protects an individual's right to possess a firearm. So for the very first time, basically it says that the Second Amendment, in fact, does protect this idea of the actual possession of a firearm. Then we have McDonald versus Chicago, which effectively incorporates District of Columbia versus Heller to the states. It says, listen, Heller should also expand to the states as well. That if you are in a state, you are protected and you have the right to possess a firearm under the Second Amendment. All right, so now the fun stuff. Rights of persons accused of crimes. So with this, we have a big concept called procedural due process. Star this, highlight it, circle it, bubble it. This is something that we're going to talk about a lot, and this always comes up on the AP exam. And so procedural due process basically says, hey, these are procedures and policies that authorities have to follow for a person to be lawfully punished for something. Okay, so if you and I were both arrested for littering, okay, you and I, as we are entering the legal system, are going to experience the same processes, the same legal processes. Okay, we're going to have our mugshot taken, our fingerprints, we're going to be handcuffed. Like, we're going to have the same processes and procedures happen, regardless of who we are. And this is going to be laid out in the Constitution in several rights, including the Fourth, Fifth, Sixth, and Eighth. And so here we see that the Fourth Amendment specifically says that we have the due process protection against unreasonable searches and seizure, and that if we are arrested, okay, that we have to have probable cause that we have committed a crime before we can be arrested. So that probable cause part. So the Fourth Amendment, again, search and seizure, and then probable cause. With the Fifth Amendment, we are constitutionally protected from incriminating ourselves. Okay, we are constitutionally protected against double jeopardy, and we cannot be deprived of life, liberty, or property without proper legal proceedings. This idea of due process. So the Fifth Amendment says, hey, if I'm going to take away your right to be active in the community as a citizen and put you in jail, then I have to go through a certain legal process to make sure that what I'm doing is constitutional. And so that is called due process. And then in order to do that, you have to have counsel, right? So the Sixth Amendment says, hey, you have the right to be represented by an attorney and can demand to speak to an attorney before responding to any questions from law enforcement. And so here is a piece of legal advice, always, okay? If you are ever arrested, okay, arrested, like you are in handcuffs, you are in the cop car, you are down at the station, do not say anything, keep your mouth shut, and say, I would like to speak to my attorney. Now, if you say, I want to speak to my parents, that has less weight than if you say, I want to speak to an attorney, okay? And then the Sixth Amendment also says, hey, you have to be prompt. You can't be sitting around in jail while we think of reasons why you should be arrested, okay? And so this basically says, listen, you have a right to be arraigned promptly and informed of your charges. Okay, so why are we arresting you? What did you do wrong? Confront witnesses. Has someone testified or is going to testify against you? And then have a speedy and impartial jury. So the Sixth Amendment gives us those protections. And then lastly, with Eighth Amendment, we have bail. So you're protected against excessive bail or fine. So as a teacher, if I get arrested for, I don't know, vandalism because I hit my neighbor's mailbox with a baseball bat, okay, then I will have to maybe have a bond or a bail to get out of jail. And it can't be excessive. So again, I'm a teacher, so the bail can't be like $10 million. Okay, $10 million. The bail has to be reasonable. And then lastly, cruel and unusual punishment. Basically, the Constitution says you are protected from cruel and unusual punishment. However, it is really vague as to what that actually means. All right. As we talk about due process, there is 4 phases that this occurs in when you are going to be accused of a crime, okay? So we have the suspicion phase, okay? Again, this goes back to that Fourth Amendment, unreasonable search and seizure. Basically, police aren't allowed to search you unless there is probable cause, okay? Probable cause. And if there's probable cause that a crime occurred, then the police are going to get a warrant. If they get a warrant, then they can search your stuff, okay? However, there are some circumstances where warrantless searches are allowed. And one of the things, or one of the places that it is allowed, is in schools, and where school administrators can search all the time, always, for drugs or weapons, okay? And then we have our arrest phase. So phase 1, suspicion. Phase 2, arrest. This is where we have that Fifth Amendment protection against self-incrimination. You don't have to say that you're guilty, right? Even if you are, you don't have to incriminate yourself. You can plead the Fifth. And then second, we have what's called the Miranda rights. Okay, and this was a 1966 case, Miranda versus Arizona, that basically says that you cannot be interrogated until you've been warned that your words can be used as evidence. And so if you turn on any legal or cop show, you have the right to remain silent. Anything you say or do can be used against you in the court of law. Well, guess what? It will be used against you. So if you're sitting in the back of the cop car and you're blabbing about all the things you did wrong, all of those things are going to be used against you. So always keep your mouth shut. Okay? All right, so the next phase we have is the trial phase. Okay, the right to a fair trial. So the Fifth and Sixth Amendment kind of get us into this mode where the Fifth Amendment says, hey, you can't be tried for a federal crime unless you're indicted by a grand jury. States are not, however, required to give a grand jury. Then we have our Sixth Amendment, which is a right to legal counsel before and during a trial. You have the right to an attorney always and under all circumstances. Okay? Criminal defendants also have the right to a speedy trial and to confront the witnesses against them. Okay? Now, this is the fun part. We have this rule called the exclusionary rule. And basically this means that if there is any evidence obtained in violation of the defendant's rights, it cannot be used. Okay? It cannot be used. Now, there are some exceptions to this rule. However, if, again, evidence is obtained against your rights, it cannot be used. And so one of the exceptions is called the good faith exception. Okay, this basically says police believe they were following proper procedures, so maybe they didn't know that they didn't actually have a warrant, or the warrant wasn't signed, or they thought they were just doing the right thing. Then inevitable discovery, basically if other evidence would have led to this same discovery, that's going to be allowable. And then plain view, basically admission if it is found in plain sight. Next, we have the sentencing phase. This is the last phase. Basically, the Eighth Amendment says, listen, you can't have cruel and unusual punishment. But we have to figure out what that is, okay? Is lethal injection cruel and unusual? Is hanging cruel and unusual? Is a firing squad cruel and unusual? Is the death penalty in and of itself cruel and unusual? And so the Supreme Court has talked about all of those different things. And so one of the things that it has been very vocal about is death penalty for minors and mentally ill. It basically says we are in no way going to ever allow those people to be killed by the state. Okay, we're just not going to do that. That is going to be a constitutional ban against having the death penalty for minors and the mentally ill. Okay, so again, just to reiterate, Miranda rights. Okay, we know those are good things, and this has affected police practices because now police have to do that. Okay, they have to do that. There are also constitutional rights that are applied, unfortunately, unevenly. Okay, so a lot of times we have racial profiling, which is the targeting of individuals from minority groups. We don't necessarily think that it is often intentional, but it can be. It can be. Okay. All right. So all of that said, what happens in times of war, right? What happens to our rights after 9/11, for example? And the quick and easy question is, it depends. Okay, it depends. Individual rights kind of get thrown to the wayside whenever there is some sort of national security threat. We saw this especially during World War II when the Japanese Americans on the West Coast were detained. Okay, and that then Congress upheld the quorum, or excuse me, Congress's actions were upheld in Korematsu versus United States. All right, so that's going to do it for Unit 3, Part 1 notes. I hope you have a wonderful day, and we'll talk more about this soon. All right, see you later.